Melania Trump is trying this desperate new tactic in a bombshell Epstein lawsuit against her. That's right, there's an Epstein lawsuit against her that involves her name.
This is an update about my lawsuit against the First Lady of the United States. I think she's running from us. By suing her, we have the right to subpoena her and her husband.
Donald Trump and Jeffrey Epstein had this deep relationship. They knew everything about each other, and then they fell out with enormous acrimony. But for more than a decade, that's what they were doing.
In October, author and journalist Michael Wolff received a letter from attorneys representing Melania Trump. The message was clear: retract statements connecting her to Jeffrey Epstein, apologize publicly, or face a defamation lawsuit demanding damages reportedly as high as $1 billion. A number designed to do one thing above all else: end the conversation. Wolff didn't see it that way. Instead of backing down, he did something unexpected. He sued first, in New York State Court.
They've threatened and sued other people for related statements about Melania Trump's relationship with Epstein.
That the legal threat itself was meant to intimidate. That it wasn't about truth or falsehood. It was about silencing discussion tied to Epstein and the social circles surrounding him.
Several days ago, I was notified by lawyers for the First Lady that they intend to sue me for $1 billion for some of those statements.
And once a case enters a courtroom, stories stop being abstract. They become sworn. Wolff made his intention clear. If this proceeds, he wants testimony. Under oath. He wants answers about what kind of relationship existed, if any, between Epstein and the Trumps. And that's where the story quietly shifted lanes. Because Melania Trump did not respond by filing the massive defamation lawsuit the letter had threatened. There was no immediate countersuit. Instead, her legal team moved to transfer the case out of New York State Court and into federal court. The reason: jurisdiction. They argued that Melania Trump is not a New York resident. They argued she lives in Florida. On the surface, that sounds like routine legal maneuvering. But jurisdiction isn't just paperwork. Because when residency is challenged, the court is allowed to ask questions. Not casual questions. Formal ones. Where do you live? Where do you vote? Where do you pay taxes? Where are your properties? Where do you spend most of your time? And those questions don't exist in isolation. They exist on timelines. Timelines that, in this case, stretch back decades. Here, where things get uncomfortable. According to Wolff's filings, attempts were made to serve Melania Trump legal papers in multiple locations. Florida, Washington, D.C., Mar-a-Lago. No success. But when his team attempted service at Trump Tower in Manhattan, they claim security confirmed she lives there. If that claim is disputed, and it is, the court may need to resolve it. And resolving it doesn't happen through press statements. It happens through records, flight logs, residency declarations, tax filings, schedules. This is how legal cases pull the past into the present. And this is why Epstein's name keeps resurfacing. Because Epstein's world was built on social proximity. Models, agents, events, private gatherings. And according to public reporting, Melania Trump worked in modeling and fashion circles long before she met Donald Trump. That alone proves nothing, but it places her undeniably in overlapping environments. Environments where Epstein and Ghislaine Maxwell were known fixtures. That's not an accusation. That's context. And in legal cases, context matters. Michael Wolff has claimed, repeatedly, that Melania Trump may have known Epstein socially before meeting Donald Trump. He has not provided public proof of criminal conduct. He has not claimed a documented sexual relationship. What he has claimed is knowledge, proximity, and overlap. Claims that Melania Trump's legal team strongly disputes. And this is where rumors rush in to fill the silence. Online speculation exploded. Unverified claims spread. Baseless theories multiplied, including rumors questioning Baron Trump's paternity. Let's be absolutely clear. There is no credible evidence supporting those claims. They exist in conspiracy spaces, not court records. But rumors don't need proof to spread. They only need oxygen. And court battles provide plenty. Adding another layer, reports emerged about Melania Trump being highly protective of her son. Accounts from gossip columns claimed that guests at Mar-a-Lago events were warned against photographing Baron. Anyone caught doing so could face expulsion or bans. Again, not criminal, not suspicious on its own. But when layered onto a case involving sworn testimony, residency disputes, and Epstein-linked timelines, everything becomes amplified. Every move is scrutinized. Every silence is interpreted. And then came another detail. A documentary project reportedly involving Melania Trump, with a budget said to be tens of millions of dollars. The director, a filmmaker whose name has appeared in Epstein-related reporting. That doesn't imply wrongdoing. But optics matter, especially in a story where the central tension isn't guilt, it's exposure. Here's the truth most people miss. This isn't about proving something happened. It's about whether questions can be asked. Because once someone is under oath, the scope changes. Lawyers don't ask gossip questions. They ask timeline questions. Where were you living in this year? Who introduced you to whom? Which events did you attend? Which agencies represented you? Who was present? And answers are no longer conversational. They're binding. This is why the Epstein story never fully ends. Because his network was wide, social, and deliberately opaque. And because power doesn't like depositions. Donald Trump has dismissed renewed interest in Epstein as boring. He said if there's credible information, let it come out. That's a confident statement. But courts don't deal in confidence. They deal in records. And that's the risk in threatening massive lawsuits. Sometimes the attempt to silence a story becomes the mechanism that revives it. Michael Wolff may lose his case. It could be dismissed, transferred, delayed, but the damage or impact doesn't wait for verdicts. It happens the moment sworn testimony becomes possible.